Legally Speaking with me, Tarun Nangia. Today, we're going to, in our part 2, discuss the judgment of the Supreme Court in the Gayatri Balasamy case, where the power to modify arbitral awards in certain circumstances has been upheld by 4:1. Of course, we all know that Justice K.V. Vishwanathan authored a dissent in verdict. To what extent has he dissented? Of course, we will get to know as we get onto the show. But what is the importance of this judgment authored by the 5-judge bench comprising of Chief Justice of India, Justice Sanjeev Khanna, Justice Bhushan Gavai, Justice Sanjay Kumar, Justice A.G. Masih, and Justice K.V. Vishwanathan? That we will get to know in a bit. I want to welcome Justice Sanjay Kishan Kaul on the show. As we all know, he's a leading arbitrator, also a mediator. He served as a judge of the Supreme Court of India and also as the member of the all-important and powerful collegium of the Supreme Court. Good to see you, sir, and looking forward to some insights from you.
Thank you. Thank you, Dharan.
We have with us Dr. Sanjeev Gevawat. He wears dual hats. He is the Group General Counsel of the SR Group, but he also serves as the Managing Director of the group. Good to see you, Dr. Gevawat, and looking forward to your frank opinion on all these issues. As always, you never are known to mince words, and that's why we appreciate you always. We have with us Senior Advocate Arvind Verma, who practices at the Supreme Court of India. Good to see you, Mr. Verma. Thank you for your time. Looking forward to your insight.
Thank you, Tarun. Thank you, everybody.
Among others, we are joined by Advocate Karthik Seth, who joins us from Bharat Mandapan. Incidentally, we managed to wriggle him out of an event which he's attending, incidentally on mediation. But today, of course, we are going to discuss arbitration. Good to see you, Karthik. You also have on the show Senior Advocate Divyam Agarwal. He's partner with Jyoti Sagar Associates in the dispute resolution practice. And Divyam represents one of the leading law firms of India and has extensive experience in the dispute resolution domain. Good to see you, Divyam, and looking forward to your insights.
Thank you. Good to be here.
At the outset, let me request if Justice Sanjay Kishan Kaul in the next 3 to 4 minutes can explain on how he sees this judgment and also what is his view on Justice K.V. Vishwanathan's dissenting verdict. Over to you, sir.
So Tarun, as in sometimes in court, I find myself in minority. I somehow tend to agree with what Justice Vishwanathan has written. And on reading through this judgment, which has recently come, I am not somehow able to persuade myself to the majority view. Primarily, there has been innovativeness by which the majority has tried to structure its judgment. But in a matter of commercial arbitrations, where the statute is so clear, I don't think it called for any a different interpretation to it. See, we borrowed from the model law, which was there. Some countries like Singapore and England have considered it appropriate that there should be a power to modify the award. We have not done it. Statute has not done it. Therefore, it is my view that at best, the court could have asked, as it happens in a recent judgment thereafter of Justice Pardiwala, while dealing with the issue of who are parties to an arbitration award, to say that consider this and incorporate it. The rationale has been that, when you set aside an award, it causes a lot of complications. Everything gets starts de novo. Well, that's how it is. Let's understand the arbitration process itself is based on a party autonomy, a party choice. You are not going through a court process in a particular manner. You have taken an alternative route. When you've taken the alternative route, you must succeed or fail by that route. That's why the civil code doesn't apply there. Now, when you've chosen your judge, you actually choose your judge in this, which doesn't happen in civil proceedings. Then you know what you are in for. Now, if we start modifying it, my apprehension is, see, awards are filed here in district courts, awards are filed in high courts. Now, what will happen is that there will be a plethora of cases which will start opening on whether there can be segregation of some portion of the award from the other or not. And whether the remaining can be enforced. Now, if there is something which falls within the parameters of Section 34, that availability is already there. Beyond the 34.4, I don't think there was any reason why something more should have been expounded. There will be odd out cases. That's how it arises. Similarly, for interest. Now, where do we get this power for interest? You can still send it back under the provisions of the Act for the tribunal remanded. But if we start saying that it should not be 6%, it should be 7%, or 7% should be 6%, I think we are in a little problem. And the last aspect also of this, in this I would say, is 142. I find it very difficult to accept in commercial arbitrations. 142 is something which should be utilized to do complete justice between the parties. It's a Pandora's box being opened. As it is, the time frame taken by for arbitration in our system is much more. We can't compare with how quickly it goes in Singapore, in England, and incorporate their methodologies. We have a scrutiny of the arbitrator, the single judge, the division bench, the Supreme Court, the review jurisdiction, the curative jurisdiction. And we have half a dozen scrutiny as it is. And expanding this area, I think, is hugely problematic. In fact, in the arbitration group, which I am now a party, many of my peers are agreeing with me. Something started with earlier by somebody else, and I said, I agree. That 142 certainly is not something, it's hugely problematic to get into it. That's how I would sum up. And therefore, I feel that Justice Vishwanathan's view, legally, I would tend to agree with that.
Thank you. Thank you for the opening comment. Thanks for being frank as usual. I'll go to another frank person who I know, Dr. Sanjeev Gemawat, Group GC of SR Group. If you could sum up in a few words what you thought of this judgment and where are we headed and what is your view on this judgment?
Thank you very much, Tarun, for having me. I echo the similar sentiments as Justice Kaur has expressed. I completely agree with what Justice Vishwanathan has given in his minority view. And for two reasons mainly, Tarun, and just appreciate it. All this arbitral ecosystem is for the commercial world, it's for the business world. So all judgments need to be evaluated and tested on basic parameters of the dispute resolution system which we are having for the commercial world. And these parameters are very simple. These are inherent, parameters as far as arbitral system is concerned. That is whether it is helping in terms of saving of time, whether it is helping in terms of saving of cost, whether it is bringing me certainty, and whether it is strengthening my enforceability. Now, on these four parameters, if any order is tested, and if suppose this is tested, I would say that I would welcome that. But unfortunately, it is not. This is not happening. And now I will come to the second aspect of this discussion. And second aspect is that legally, the way in which I understand law or I understand constitutional failure, I don't think that this judgment, majority way, is in line with the mandate given by the law. And I will give you reasons why it is not on that line. Very, very, briefly. The arbitral award can be challenged on certain reasons, certain causes. One is if there are errors, mistakes. This is one area. Second area is if the process is flawed, understandable. Third is that if the appreciation of evidence or appreciation of facts have not been done properly, this can be a third reason. And fourth reason can be that evaluation of law or in terms of applicability of law or application of law has not been appreciated properly. These are broadly the four reasons why the awards get challenged. Now, if you notice all these four reasons, the first reason is to provide that mechanism. If there are errors or mistakes, there is a section 33 already available to you. If there's a flawed process, then you have section 34 already available to you. Now, in this backdrop, and in fact, as regard the other two aspects is concerned in terms of the appreciation of evidence or reappreciation of evidence or erroneous application of law, it is already barred as far as section 34 or section 2A is concerned in terms of that provision. Now, And even if that happens in terms of application of law or the reappreciation of evidence, that need to be falling under the purview of Section 34. Now, if you already have all those rights available under the present statute, I don't think that judicial innovation should lead to something, as Justice Call is rightly pointing out, that I fail to understand why Article 142 can be invoked. Even I am saying the basic thing, it cannot be invoked for the commercial world where two mature parties are entering into a commercial contract and with open mind. I don't think that 142 should be invoked as far as the commercial contracts are concerned. I fail to understand why this post forward interest, you are assuming those powers on the post forward interest. If this power is not given to you, this power is already available under Section 31. How can you assume that power? That is power available to the arbitral tribunal. I don't think that you can be assuming that. And as regards, yes, I can welcome this judgment from this perspective, Tarun, that today in arbitral ecosystem, what we are having in India, it's largely ad hoc arbitration. And in ad hoc arbitration, you need certain checks and balances. And checks and balances essentially means that if suppose something is going wrong, you need to be applying your law. And to that extent, I would welcome modification. And it's not that the modification was not happening earlier. In fact, this judgment is bringing that clarity. And so far as there is a severability, I would say that perhaps this would help in terms of saving of time and cost. But broadly speaking, with this part of this appreciation or welcome step in terms of you are giving that clarity to modification, by this judgment, this is perhaps maybe the welcome thing. But again, if you go to the inherent four parameters which I mentioned, whether this would lead to time, cost, enforceability, certainty, answer is no. And so I think, for want of a better word, I would say regressive kind of, steps in a way. Rather than solving the problem, we are creating a problem.
Thank you. Thank you for your opening comment. I'll go to Divyam Agarwal, partner, Jyoti Sagar Associates, for his opening comment.
Thank you. Thank you, Tarun, for having me. And I echo the sentiment of Justice Kaul as well as Dr. Gimawat. With this decision, for now, a quietus has been put to the seemingly endless tussle between finality and modification of award. However, we will see that certain elements of the decision introduce a degree of subjectivity, which, knowing the mindsets of Indian litigants, unfortunately, can become a fertile ground for continuation of similar issues. Now, taking a cue from what Dr. Gimawat and Justice Kaul said on Article 142, Article 142, unfortunately, has been the unruly horse. And applying this 142 truly introduces equity in the arbitration landscape, even though the Arbitration Act itself bars decisions based on consideration of fairness and equity, unless the parties, of course, expressly agree to that effect. So I echo that sentiment. Also, time and again, globally, the courts, and I'm a dual qualified, I'm an English solicitor as well. So globally, there is an underscore need to balance between minimal judicial intervention and the objectivity of speedy resolution of disputes through arbitration. I feel a clear legislative amendment may be necessary to circumscribe such powers by delineating circumstances in which they can be exercised. This is so because an uncharted power to modification may itself lead to lengthening the arbitral process. As my opening comment, I think I totally subscribe to the view given by the esteemed panelist. And I agree that we may have to look into it more deeply, and perhaps the legislature needs to look into it more deeply going forward. But for the time being, a quietus has been put on this issue, and on some aspects, there is the majority decision is welcome, as it tries to iron out the creases on some burning issues which have been going on for eons now.
Thank you for the opening comment. Now we'll go to Senior Advocate Arvind Verma and then Advocate Karthik Seth for their opening comments on the judgment. Over to you, Mr. Verma.
Yes, thank you, Tarun, for it's a privilege to be here. And I wholeheartedly endorse the view expressed by Honorable Justice Kaul. I've always agreed with him, having appeared before him in the Delhi High Court and in the Supreme Court. I have the privilege of assisting him at the bar also. But that's that apart. And also Dr. Jamawat and Divyam has also put a very balanced and a very, which I also agree that though I agree with Justice Kaul and Dr. Jamawat that the minority view has come in as a breath of fresh air. It has come in as a breath of air, exercising caution and restraint, which some of our last of the great judges like Justice Kaul have also exercised in 142 and various other matters. But I also feel, I'll just add a few things here. The majority view offers a course correction. It recognizes that while the Act does not explicitly authorize modification, it also conversely does not expressly prohibit modification. The silence in the acts is deliberate. The design is deliberate, in my humble opinion. As Justice Kaul said, it aligns with the unilateral model law. Our act is structured in the same way. It's a party autonomy. Parties subscribe to it under Section 11. That is, they are bound by the arbitrator. But when it comes to certain other issues, when that need arises, especially when the exorbitant amount of interest imposed by arbitrators without any reasoning, that is when the courts under 34, 37, or the Supreme Court, they have to step in. I just feel that the majority view has also exercised. It says that while the Act does not explicitly authorize modification, they acknowledge a few short points. It recognizes judicial power to correct patent errors, patent illegality as flowed from associated builders to Sanyong as present. It allows modification of post-award interest, as I said. Also, more importantly, the Arbitration Act, though may not use the word modify, but the silence should not be mistaken for a ban. Modify, the silence in 34, 37, that you cannot modify. In my humble opinion, it should not be mistaken for a ban. Therefore, the majority view has interpreted that silence to allow limited, narrowly tailored intervention. So that is what I just feel that the majority, though I agree with Justice Kaul, Dr. Jamawat, but I agree a little more with Divyam Agarwal on this issue, that the time has come that earlier when we appeared, although I have had a very bad success rate in Section 34 matters, most of them I have lost. So as for the petitioner, but the fact is that certainly we are conscious, parties conscious, councils are conscious, the Honorable Court is conscious that it's not like a first appeal arising out of a suit. But certainly now with the Arbitration Act progressing exorbitant amount of interest and others, so those I just feel that the majority view has also stepped in to express what the Arbitration Act impliedly says, has not said. So
Point very well taken. You were saying something? You want to comment?
yes, so that is so far as certainly the 34, 37 are very clear that there's no power to modify the awards in that express terms. So I just feel, though I entirely agree, it's Justice Vishwanathan's judgment it's a word of caution for not exercising that power under 142. But the majority view is, I would say, it's a course correction. It's a course correction. So that's my view.
Point very well taken. I'll go to Advocate Karthik Seth for his reflections on this judgment and its impact on the Indian arbitration landscape.
Yeah, thank you, Tarun, for giving me this opportunity among such esteemed panelists. So I have a slightly different take. Would be pardoned for it. I completely agree with certain usage of word with regard to regressive step, etc. But probably this is not the beginning of it. It began in 2014 when Justice Thakur's authored judgment in 3 GECO was pronounced. That was the first time when a modification was allowed, where a three-judge bench specifically did something like this and modified. Now, thereafter, M.A. Hakim happened. And thereafter, there was Sangyong. So, I mean, like, I've had the privilege, today only there was an Arvind Datta's senior advocate's article which was published, where he analyzed the judgment. And when I got an opportunity to look at it, he specifically said that if this was supposed to be looked at as a regressive step, then probably it started in 2014 when JECO happened. And when that happened, it should have been at a different particular place altogether. See, so what we are at a particular stage where we need to figure out what could have been in any other place, what could have been any other method, apart from a majority decision forcing upon the legislature to take a decision and probably amend the Section 34. And that, in my opinion, is the majority view. So, what is the most important thing at this point of time in like the narrow approach which I want to take is, I agree that Article 142 is not something which should have been taken into consideration. But since 2014, the government was not doing anything. The legislature were not doing anything. There were so many judgments back to back happening here and there where there was modification, there was no modification. So court had to intervene. And what else? I mean, like, I remember I was with a senior advocate who was a former law minister, I don't want to name him. He used to say that Article 142 में Supreme Court judge भगवान है, वो कुछ भी कर सकता है. और किया है उन्होंने. I mean, like, to be very honest, I mean, like, there's no harm in it doing when the government was not doing anything with regard to the modification which was required. So that's my opening comment on it. Thank you. You're muted by.
Thank you for that opening comment, Karthik, on 142 and your reference to God. I'll go to Justice Kaul for his interpretation, because amongst all of us, only he has sat in that chair. So, and also, if you could reflect on the fact that reduction or reducing interest rate at the appellate stage in the Supreme Court, do you think it will modify the award if the judge thinks that, the interest rate is way too much and let's reduce, because the case has been after the award in courts for 8-9 years and the interest amount is now too high? If you could reflect on those points.
So, Tarun, on the first aspect, I don't think this is a mistaken belief that we have some power of God. I used to always say, if there was a court above us, half our orders would also have been set aside. It's just that there is nobody above us to judicially deal with us. If President had this power and exercised the power, the same fate would have arisen with us also. Now, it's in particular situation this has to be used and used very carefully. Otherwise, what happens is, we are using it to substitute where a legislation is not present or the legislature is not desirous. So, taking cue from what Mr. Karthik said, that the government is not doing it. So, if the government doesn't modify a civil procedure code, can we say we will modify civil procedure code? If the government doesn't modify IPC, can we say we can modify IPC? We can't. We must exercise the jurisdiction given to us. Otherwise, this balance between the legislature and the judiciary and the executive gets disturbed and creates a problem. We can't be some kind of a repository of all knowledge and say we know what is best for it. The parliament doesn't know what is best for it. So if you parliament don't do it, we'll do it. That's why the principle of recommendation which is there is there. You may recommend, the parliament will debate it out, as I feel has happened in the last the couple of days back, only judgment of 2 judges bench which is arisen. Therefore, 142 is one caveat. Also, see, when we say interest should be X, interest should be Y, it has been pending for 9 years. Why is it pending for 9 years? Who is it responsible for pending for 9 years? So countries which will have a more expeditious disposal system will adhere to the interest regime, but we are not able to dispose it off. So in our wisdom, we'll do so. The problem is the discretion will vary. It's like the foot of the chancellor. It will keep on varying from judge to judge. And more cases will come up. What will happen is, people will say, every case will come up to the Supreme Court. because they say we never know in which case 142 may be exercised. It will also vary depending on, with due respect, which judge is hearing it, because there are differences in perceptions on certain issues between different judges, how commercial litigation should be dealt with. The fundamental point, which I think was made in the beginning, was by Mr. Gemawat, that these are not parties who are unaware. These are not unequal battles in that sense. They are commercial, well-versed parties. Of course, there may be somebody commercially stronger, somebody commercially lesser strong, but they're all commercial parties who choose the route of arbitration as a methodology. Then you swim or sink with it, unfortunately. There is no perfect manner of doing so. You could have gone to a civil proceeding. You could have agreed that no, this will be decided in a civil suit. You say no, it will be decided in arbitration in a particular manner, whether by a single arbitrator or two, one arbitrator being appointed and the third one being appointed. So therefore, I have some reservation even on this expanding notions of Section 34, which will arise, because even by segregating, this problem will arise. In any case, if it is something without complete jurisdiction, there is a provision in Section 34. That part can be segregated. Now, why add to it? And if the legislature in its wisdom feels that no, the only method is for the award to be set aside and to begin the chapter again, merely because we feel that we are not able to adjudicate disputes within a time-bound schedule, we should adopt a different approach rather than amending the act. So I have a great caveat over this issue that if legislature doesn't do it, the judiciary will do it. I personally believe that's not how it can be done. The elected body will enact the law which is there. Yes, there are cases where there is vacuum. In those cases, like Vishaka Supreme Court stepped in. These were social issues on which it stepped in. But not in hardcore commercial dispute resolution. You will otherwise have, look at the nature of arguments which will take place. Huge amount of time is going to be spent, you wait and see on these issues before the courts as to what can be segregated, what can't be segregated, how that portion is awarded there. It will be like hearing a first appeal, which is not what is envisaged. This is my concern that given the Indian scenario, it is going to further take much longer to decide the commercial disputes if there is no clarity by a legislative amendment. If a legislative amendment comes, well and good, whatever manner, and then they will see to it that in what manner it operates. Maybe it's right that there was some kind of a obfuscation on this issue between different judgments of the court, so the court has tried to give a rest to that and do so. But I, I, I would still say that I think the Vishwanathan is the correct expression of the legal view which is there.
Point very well taken. I'll go to Dr. Gemawat for his view. Yes.
Yeah. Any specific question or?
Two points. On the part of the court to sever the award, which is sever a part of the award which they think is not right or invalid. Second, on the issue of interest, because most disputes at the Supreme Court level are about varying opinions on interest, because by the time it reaches the Supreme Court, the award plus interest becomes itself a very big issue. And in case after case, we have seen this.
But the way in which I look at it is that all these changes, they need to be seen for the seen in the context of the parties who would be invoking these processes. Now, just think about it. The court's judgment, whether they are passed in Article 142 or in any manner, they are not being used only at the different levels, say Mumbai High Court or Delhi High Court, where there's a high level of maturity in terms of the legal ecosystem. They are being followed across the board. Now, in that context, if you analyze this, whether that is your, the issue on the interest part or any other, issue also, you will realize that this is not the domain of the courts. The moment you take those issues in your fold, you are encouraging multiple litigations in an environment where, believe me, Tarun, Section 34s are pending for last 10 years, 15 years. That is the state of affairs. And in this kind of a state of affairs, by these kinds of litigation, are we not encouraging more litigation? Just think about, I will just use a couple of more points also. Para 84 of the main judgment, it says, and rightly says so, that arbitral tribunal cannot rewrite judgment, or the courts cannot rewrite judgment. In fact, not judgment, rewriting a contract by way of a judgment. Now, this is one of the grounds in Section 34 when we take that the arbitral tribunal has rewritten a contract between the parties. They have gone beyond the contract. Now, that is a ground of 34. Just read Section Para 84. The way in which it is worded, it is in fact saying that you can rewrite the contract between the parties by invoking Article 142. So I think now coming to interest part again, when you mentioned, now interest is a commercial issue. Even if that is a legal issue, that is already provided under Section 31 of the Arbitration Act. Why are you using these tactics in terms of getting into the domain of that commercial work? It doesn't make sense to me. Now, I would just make one more comment, and which was Karthik said, and I think Justice Kaul also expressed on that. I think last 10 years, 15 years, I am saying government is very, very proactive in terms of coming out with the changes in the legislative framework. The moment something happens in terms of one or the other orders of the court, government is, very proactive in terms of making those amendments happen. Some of the legislative framework which the government has came out, like the Mediation Act of 23, etc. I think these are all, very good piece of legislation. Now, what I was expecting through the court judgments is that the alternative dispute resolution mechanism, which has already taken a backseat in the Indian context, perhaps to pass some judgments of that nature so that the commercial world would have an effective and robust dispute resolution mechanism. Today, with litigation in the court system, we don't have that infrastructure. With these kinds of judgments and where ad hoc arbitration is dominating the world, you will keep on having multiple litigation. So better to focus on creating a credible institution. And if you pass judgments to that effect, if you say that no modification is possible, something of that nature, which would strengthen your legal ecosystem on dispute resolution, I think that would have been a nicer thing. I would also like to highlight, I read with a lot of interest Para 114 of Justice Vishwanathan's judgment. Very interesting. And he has made this, he said that it's all antithetical to the basic inherent issue of arbitration. I think, I echo those kinds of sentiments. But yes, it's high time that we should be reforming our dispute resolution mechanism and, particularly the arbitration system. The businesses of arbitration is going abroad now. We can't think of India becoming an arbitration hub. No longer now.
Point very well taken. To encourage arbitration, of course, a lot more needs to be done in India. But I'll go to Divyam Agarwal on the issue of post-award interest, because the judgment speaks about the ability to modify post-award interest. Do you think that becoming a problem, or think that parties will accept it happily, given the fact that it generally takes very long after the award is written for it to be adjudicated in the courts and then enforced thereafter?
So I agree with Dr. Gemavat's view. Interest is not something, it's a commercially minded arrangement between the parties, and they have already thought through this. They have already provided a procedure to it. So I also feel that it will present its own set of challenges, as interest has always been a substantive issue, having many factors in place such as contractual stipulation, legal provisions, economic conditions of the market, and industry to which the dispute relates. So I feel there are going to be a set of challenges around it. Additionally, there is a requirement to provide compelling and well-founded reasons. The majority says that there is a requirement to provide for modifying interest. It remains to be seen how these reasons can be demonstrated without going into the facts and evidence involved in the dispute, which is something which, in my view, should be left to the domain of the arbitrator and not courts. I'll also, so this is my bit on the interest. I'll also reflect on two more points which have been discussed. One is the issue on severability. Severability, and if you have noted that severability, there is a concurrence between all the 5 judges. So it's not a dissenting opinion of Justice Vishwanathan on it. Severability as a concept, again, it has been much debated. It is essentially is annulment of a bad part of the award and not alteration. There are judgments like J.C. Buddhi Raja, J.G. Engineers, etc., where this principle has been noted. This is in my view a welcome view of the entire 5 judges, as this saves considerable cost and time and save parties from additional rounds of litigations. Court may choose to exercise the bad portion from the award. They may exercise it and without having to set aside the entire award. The last point I wanted to make on another topical issue when it comes to this judgment is the view on the clerical typographical errors. Again, this is a concurrent view given by Justice Vishwanathan to the majority decision. However, they use a particular term and which has been reflected in both the decisions, that they say their court under 34 can rectify clerical, typographical, and computational errors. My bit of a difficulty is with the word computational. See, and I would say more than everybody, Dr. Gemawat would agree, is coming from that infrastructure industry. When there are formulas like Hudson, Emden are in play, then when you get into the computation, you will necessarily have to look at what kind of a formula that has been applied, which in turn would mean that you have to delve into the facts of us to a certain extent, even though arbitrators are the master of evidence, and even though the majority, in fact, cautions that there should not be any merit-based evaluation. Unfortunately, that gap would still remain, and one has to see how this gap is bridged by courts going forward.
Point very well taken. And on that last point also is pretty interesting. You brought out computational errors because that opens a completely new discussion, to what all will be scrutinized at the court level. I'll go to Senior Advocate Atil Verma for his intervention.
Yes, I'll just add to a few things what Justice Kaul said and what Dr. Gemawat said. Certainly, Dr. Gemawat took the words out of my mouth of para 114 of Justice Vishwanathan's judgment. It's an eye catcher. But I would again say that the majority view has laid down certain strict boundaries. I would, as a counsel, I would say that certain boundaries where they've also underlined the fact of preserving the core award. They've also said they've kept an eye, they've kept a watchful eye on preserving the core award. When it comes to post-award interest. Now, post-award interest, to my mind, with my limited experience, has given a lot of uncertainty to clients. It has led to immense litigation. So I would feel that the majority view, while it should be open to the courts, that for upward, downward, as Dr. Gemawat said, the commercial understanding in commercial parlance, parties are aware of what would be the commercial repercussions in a matter. So upward, downward revision it's not necessarily interfering with a very well awarded award. Because I just feel the best of awards have been set aside, a perfectly reasoned award have been set aside on this post-award interest. And there have been fights right from this section 34, 37, right up to the Honorable Supreme Court on this. So I would say that there's a balance. The majority view, certainly, this is my subject to correction. This is my view that they have kept a few boundaries. They've kept these few boundaries, but an eye on preserving the core of the award. Post-award interest modification does not take away, as Mr. Agarwal said, that it's a substantive issue. It's not just a technical typographical computation issue is different. So to my mind, the majority view has held that the arbitrator's power is not unlimited. When it comes to post-award interest, it will lead to lots of clients have suffered in my limited jurisdiction. So that's my thing on post-award.
Point very well taken. I'll go to Advocate Karthik said to address on these very two issues, the post-award interest bit and severing the award, that bit also. Of course, to what Divyam also spoke, if you could address that on computation, because that is a new point that he brought forth.
Yeah, yeah. Firstly, I mean, like, obviously, we are learning every day. And when Sir, I mean, Justice Call rightly pointed out that just because the legislature is sitting on something, we cannot take it upon ourselves and keep doing that. I completely agree with that particular portion. So I was not on that particular aspect where we, like, the judiciary takes upon a role and starts, goes on a rampage and starts amending laws and all that. I am definitely not on that point. Just on this particular aspect, when as you rightly pointed out, Divyam also pointed out about severability, and Dr. Gemawat said that the government has been very proactive in making amendments, and especially I'm sitting in a mediation conference and everyone is talking about the 2023 amendment which came into picture post judgment. So I mean, like, I understand that the government is proactive, and that is what we are perceiving, that is what we are aiming at. And I mean, like, as rightly pointed out, like, probably not in the judgment, there is a specific Singapore Act which talks about vary. There's a UK Act which talks about vary. That word vary can change everything if that particular thing is amended in section 34. And if the government, after looking at this, rather than being at crossheads with what the judgment has laid down, rather follow it and make an amendment immediately, then probably the talk about Article 142 being taken into consideration and doing it would be helpful also because of the reason. I mean, yesterday was a miscellaneous day in Supreme Court and everyone was talking about this judgment itself. And we spoke to a lot of senior advocates. And here, I mean, we have like one of the senior most Supreme Court judges who retired. We were talking about Supreme Court being a constitutional court. And are we here burdening ourselves to decide on issues of interest or issues about these kinds of, this is not the job of a Supreme Court judge to decide on, oh, what interest should be there or what will be the calculation mistake. I do a lot of energy and power sector matters and mining sector matters. We have every now and then some dispute with regard to what the interest was awarded, or there is a calculation mistake or something like that. For that to come, everyone, as Justice Call correctly pointed out, everyone will come to Supreme Court. So because of this judgment, and on that particular aspect, I genuinely feel that I agree with the complete panel that then you are just overburdening yourself rather than being a genuine constitutional court. We are deciding on what is going to be the interest, how it is going to be worked out. Almost everyone is going to come to Supreme Court, and especially people who have good commercial interest or, I mean, good commercial power will straight away come to Supreme Court and not go anywhere. Just on the severability point, it's a very, very welcome move, I feel, and that's why there is a consenting view by all five. The reason why I say so, that I'll just give an example in 10 seconds. There was a particular arbitration award which was decided on 5 issues which were framed. Out of the 5 issues, 4 issues were decided in one party's favor. 1 issue decided against them. When a 34 went in a Rajasthan commercial court, under the commercial court, there is a district judge who decides on a retired Supreme Court judge or retired whomsoever deciding, and that district judge says that I'm bound. I have to set aside the whole award, even if and when it went into a section 37, that matter till date is pending in Rajasthan High Court, where I'm appearing for a PSU, waiting for this particular judgment. So now on severability point, at least that point has been cleared, and that, in my opinion, is a very welcome move. Thank you. You're again muted.
Point very well taken, Karthik. I'll go to for one last comment because we are out of time now, to Justice Sanjay Kishan Kaul. Also on what Divyam Agarwal raised on computation. What was the word, Divyam, you shared with all of us from the judgment?
computational, clerical and typographical errors. That's
Yeah.
what it is.
Yeah. So, but you also said that then the court can get into computation.
Yes.
And then can get into evidence also.
So I will read that majority portion. So it says court under section 34 possesses the authority to rectify computational, clerical or typographical error as well as other manifest errors, provided that such modification does not necessitate a merit-based evaluation.
Point very well taken. Sir, if you could address this in your closing comment.
See, I'll give you quick three responses. One is on segregation, section 34(2)(a)(4) of the Act exists. So there is a provision to what extent it can be done. Should we expand on it? A. B, section 33 provides that the parties may approach arbitral tribunal to correct errors. Now, either there is an error or there is no error. If you don't approach within 30 days, even in a commercial dispute, to decide what is an error, what is not error, and subsequently other courts are required to go into this competition, I completely agree. This competition business will mean opening and going into facts, which is my concern. And one of the major issues is, see, it's not that every matter is being heard by a commercial court of a high court level. Many are at district levels. How that will play out is something which is troubling me. The crux of the problem, whether for interest or this other, is we take too much of time in deciding a matter. It's not an issue here, but if judges are not to be appointed, if vacancies arise, where courts are working in a system where they are not able to deal with the matters, 34s are lying for years together, I don't know how anything can address the issue unless we have the vacancies filled in and commercial courts working effectively, criminal courts working effectively, any court working effectively. Because the high courts are, according to me, many of the high courts are in a soup, complete soup, according to me, in terms of the quantum of work which they have and the strength of the matter. So, though it is not linked, I think apart from amending the laws which the legislature may be required to do, I think one of the major issues is the appointment of judges must take place in time. You have to make the system work. Solution is not what the government says. If the stakes are higher, then take it out of arbitration. If this is the approach, then why have arbitration? How do you ever expect India to be a hub of arbitration if we adopt this approach? We can't have both the things. If we have to make commercial litigation a fast-track litigation based on commerce, so that many of these issues would die out if the things did not take 9 years or took 1 year, 1.5 years. That's how I would.
Point very well taken. Indeed, I enjoyed doing this show. Some very interesting points were today brought forth on this show. This is the second part of this series. One point which Divyam brought was a fresh point that he brought on the show. Of course, we have to see how this judgment plays out for corporate India and take up those issues again. But as for now, I would like to thank Justice Sanjay Kishan Paul, Dr. Sanjeev Gemawat, Group General Counsel of SR and Managing Director, Senior Advocate Arvind Verma, Advocate Karthik Seth, Divyam Agarwal, Partner, Jyoti Sagar Associates. Appreciate your time. Thank you for joining us, and it was a very engaging discussion.
Thank you. Thank you so much.
Thank you very much.
Thank you very much, sir.
Thank you, Tarun. Thank you.